Good afternoon, jail. Can you hear us and see us? Good afternoon, jail. Can you hear us and see us?
Yes, we can.
Okay, I'm going to start the video.
Okay.
Good afternoon. Would you happen to have an extra copy of the docket? I couldn't download it from.
Yes.
It wasn't ready. Oh, okay. Yeah, I looked for it, but it was. I guess you have priority. Yeah?
The printer was running out of ink, but it
Oh,
should be okay.
okay, great, thanks. Well, now our end doesn't even show anything.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers.
Not supposed to.
Thank you.
That's what happens all the time.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre, y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
Okay. Thank you.
Good afternoon, Osceola County Jail. Can you hear me?
Yes, we can hear you, Judge.
All right, excellent. We're here for first appearances this afternoon. Just a couple general announcements on each case. I've found probable cause for all of the counts. On each case, if there's been an application for the appointment of the public defender, the clerk has found that they qualified, I will be appointing the public defender. First up, we have cases involving our interpreter. Have our interpreter's been sworn? All right, let's go ahead and swear our Spanish interpreter.
You can raise your right hand. Do you solemnly swear and affirm that you will faithfully translate from English to Spanish and from Spanish to English to the best of your ability? So help you God.
Yes, I do. Theodore Leal, L-E-A-L for the record.
First case I have is Augustin Hernandez Lopez.
He bonded, Your Honor.
All right.
I don't believe so, Judge.
Okay. Well,
That's what the jail has indicated to me.
He has an immigration detainer, so I doubt he'll be going anywhere.
Yes, he bonded on this as to this charge, though.
okay. All right. Next is Jesus Montanez.
He's coming.
Montañez.
Let's go ahead and good morning, or excuse me, good afternoon, sir. Tell me your name.
Buenas tardes, señor. Diga su nombre.
Jesús Montañez.
Sir, you've been arrested and charged with the crime of battery and act of domestic violence.
Señor, usted fue arrestado un caso que tiene que ver con violencia intrafamiliar, con una agresión doméstica.
Sí.
Yes.
I do find probable cause for that offense.
Veo que por tal delito hay indicios de culpabilidad.
It appears that you qualify for release through the pretrial release program.
Parece que usted sí califica para que sea puesto en libertad bajo la supervisión del Departamento de Libertad Provisional.
I will order your release with the following conditions.
Y voy a ordenar su liberación, pero con las siguientes condiciones.
Number one, you're released through pretrial release.
Número 1, va a estar bajo la vigilancia del Departamento de Libertad Provisional.
Number two, you must maintain a separate residence from the alleged victim while this case is pending.
Y mientras este caso está pendiente de mantener residencia separada de la presunta víctima.
I'll let you go back to the residence where the incident took place one time
Yo voy a permitirle que usted vuelva una sola vez a la residencia donde ocurrió el lugar de los hechos,
in the company of law enforcement
con la compañía de un oficial de la fuerza pública,
to recover any personal items you need while the case is pending.
para que usted recupere algunos efectos personales que usted necesite mientras el caso está pendiente.
I'll order that you otherwise have no contact with the victim while this case is pending.
Y también ordeno que bajo ninguna manera ni forma tenga contacto con la presunta víctima mientras el caso está en curso.
I'll order that you possess no weapons or firearms while this case is pending.
Ordeno también que mientras el caso está pendiente no tenga ningún tipo de arma ni armas de fuego.
I'll order that you not consume any alcoholic beverages while this case is pending.
También le prohíbo que mientras el caso esté pendiente no consuma ninguna bebida alcohólica.
State any other conditions you're going to ask for PTR.
¿Qué pide la fiscalía?
No, Your Honor. Of course, no illegal drugs.
No, señor, y tampoco
Also order
drogas.
that you not possess or consume any illegal drugs.
Y también que no posea ni tenga ningún tipo de droga ilícita.
And I'll order that you be subject to random testing through PTR at your own expense.
Y también ordeno que el Departamento de Libertad Provisional le haga las pruebas antidrogas al azar, saliendo los gastos de su bolsillo,
To ensure compliance with this court's order.
para asegurar el cumplimiento con esta orden de la Corte.
That's the order of the court in regards to Mr. Martinez.
Eso es todo.
Next court date will be April 23rd in courtroom 4E.
La próxima comparecencia, abril 23, en la Corte 4E.
All right.
Thank you.
Do we have any other cases where we need the Spanish interpreter?
¿Algún otro caso donde se necesita el intérprete de español? Levanta la mano.
I see no hands, Your Honor.
All right. I have Sandra Perez Prado. Good afternoon, ma'am. You've been arrested on a warrant out of Lake County. The judge who issued that warrant set your bond at none. You remain on a no bond status pending Lake County coming and picking you up. Good luck to you, ma'am. Next, we have Chad Kerr or Kerr.
PD approve, Your Honor.
Sir, you have two matters before the court. The first is case number 16MM2154. In that case, you had failed to appear in court. Judge Draper issued a warrant for your arrest and set bond in the amount of $2,999. I'll stay that bond pending disposition of that case. Your next case is 2016 CF 3065. You were originally arrested on a warrant in that case. Subsequently, the state attorney's office filed an information charging you with 3 crimes. Madam Clerk, it's unclear to me what the bonds are, so I'm just going to announce bonds on each of the 3 counts of the information. Sir, on count 1 of that information where you're charged with dealing in stolen property, I'm going to set bond to the amount of $10,000. On count 2, burglary of a structure, I will set bond in the amount of $5,000. And in count 3, receiving money from pawnbroker by false verification, I'll set bond in the amount of $150. I'll order that if you post bond in any of these cases, you also be released through pretrial release with weekly check-in. Order that you not possess or consume any alcohol or illegal drugs while this case is pending. That's a condition of your pretrial release and of your bond. Madam Clerk, do we have future court dates?
We do in case number 2016 MM2154. Next court date will be April the 15th, courtroom 4E, and in case number 2016 CF 3065. Next court date is going to be April the 2nd, courtroom 4F.
All right, sir. Good luck to you. Next, we have Eric Raul Lopez.
PD approved, Your Honor.
Oh, okay.
All right, sir, you were arrested on a warrant on a driving while license suspended charge. It was in regards to a violation of probation in regards to that case. The judge who issued your warrant set your bond at none. I'll stay your bond at none at this time pending disposition of that violation of probation. Next is Keith Ott. I'm sorry, do we have dates for Eric Raul Lopez?
On demand.
All right.
Your-
Next, we have Keith Ott.
Your Honor, we like to waive the reading of the charges.
All right, sir, you were arrested on a warrant. The public defender is requesting a waiver on the reading of the charges. I'll simply indicate to you that I'm staying all of the bonds that were previously set when the judge signed the warrant. Those will remain your bonds while this case is pending. Do we have future court dates for Mr. Ott?
On demand.
Next, we have Leonard Roy Pasco.
PD approved, Your Honor.
Good afternoon, sir. You've been arrested on an affidavit of violation of probation. Your bond is set at none. I'll stay your bond at none pending disposition of your violation.
Next court date will be April the 11th, 8:45, courtroom 5A.
Next, we have Cameron Andrew Rubino.
PD approved.
Good afternoon, sir. You've been arrested on a warrant for violation of probation. The judge who signed that warrant set your bond at none. I'll stay your bond at none pending disposition of your violation. Good luck to you, sir. Or, sorry, do we have future court dates for him?
April the 1st, courtroom 5F.
Next, we have Anthony Dwayne Tadlock.
PD approved.
Does he just have one case in this packet of
Yeah.
people? Okay, all right. That's fine. Good afternoon, sir. You've been arrested on a violation of probation in regards to aggravated battery upon a pregnant person. You also qualify as a violent offender of special concern. The judge who issued your warrant set your bond at none. I'm going to stay your bond at none pending disposition of your violation proceeding. Your next court date would be
April the 4th, courtroom 4F.
Next is Courtney Bromley.
Do you approve?
Got a witness as well. All right, we've got a witness here. Let's go ahead and swear the witness in.
Sir, if you can please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to enter in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
All right, tell me your name, sir. How are you connected to the defendant, Courtney Bromley? She was arrested yesterday and charged with the offense of aggravated assault with intent to commit a felony. You're the alleged victim in this case. We're not here to try the case today. I'm here to determine what conditions of release are appropriate for Ms. Bromley. What do you want to tell me on the subject of release?
Your Honor, I'm sorry, we can't hear anything.
All right, let's get that microphone closer to him.
Okay. My wife is pregnant with our first child.
Hold on, can y'all hear now?
Yes,
And
Your Honor.
Nothing at all, sir. Nothing at all. My mother called. My wife did use my registered firearm, but she did not. But she's pregnant with our first child. She doesn't have a habit of doing it. Never done it before, and wasn't going to do it. But my mother, Glance, who also lives with us, and I'm the breadwinner, of course. I drive trucks, and so does my wife, and it's our first child. But, sir, my mother saw from her room, which is adjacent to our room.
Sir, we're not here to try the case today.
I understand.
What is it
I
you're
just want you
asking me
to
to do or not do today?
let my pregnant wife go with my first child. Nothing was going to happen. Nothing was going to have happened. Won't happen. I mean, I understand, but the officers had to do their job. Yeah.
Well,
And
sir,
my-
again, today's not the day to try the case. The state attorney has to decide whether they're going to prosecute this case or not. The only issue I have is to decide what conditions of release are appropriate. Normally, when acts of domestic violence are alleged to have taken place, I order that the defendant maintain a separate residence. Are you asking me to do that or not
No,
do
sir.
that?
Of course not.
Are you telling me that you want her to come home?
My pregnant wife with our first child, of course.
Okay. Are you telling me you're not in fear of her gaining access to one of your firearms and actually pulling the trigger this time?
The officers have taken the alleged weapon and so on.
Let me ask you this. Are
I'm
you
fear of that.
Let me ask you this. Are
Yes,
you
sir.
willing to keep all firearms out of that home while this case is pending?
Absolutely, and I also want to say, I have locked boxes for my firearms. I've traveled.
That wasn't my question. Are you willing to keep all firearms out of that home while this case is pending?
Yes, sir. As well as this is our first child, and we're not have a bunch of money if bail is high. If you can take that in consideration as well.
I'm going to address that, sir. All right, Ms. Bromley, here's what I'm going to do. You need to listen very, very carefully. I do find probable cause for the offense. I am going to release you through the pretrial release program with the following conditions. Number one, you have weekly contact with pretrial release. Number two, I'm going to let you return to the residence where you live with your husband, as long as there are no firearms whatsoever in that residence. I'm going to order that you comply with any request of pretrial release to enter the home and ensure that there are no firearms in the home. I'm going to order that you have no hostile contact with your husband while this case is pending. That means no yelling, no screaming, no pushing, no shoving, certainly no pointing firearms or making threats to use firearms. State any other conditions that you're going to ask me to impose as part of PTR.
Your Honor, typically in a domestic violence case, the state always has to release terms of alcohol, even if it's not indicated to the news. Arrest affidavit to see that's for that. And RUAs, in addition, even, I just want to say for the record that the state will be concerned by the facts set forth in the arrest affidavit. The state does have concerns about the hostile contact at this point in time. The state's preference to have no contact order in place until such time as there is a distance.
We're having trouble hearing the state attorney.
Okay.
I'll start over and I'll go as fast as I can.
I'm sorry.
It's okay. So basically the state is requesting that the court order no drugs, no alcohol, RUA, which is a typical state's request in a domestic related offense. The state would also like to put on the record that the state is concerned based on the facts as set forth in the arrest affidavit about the no hostile contact order. The state's preference would have been a no contact order, period, until such time as this matter could be addressed later in division.
So, Mr. Bromley, and let's get the microphone back over. So I want one more time. You indicate that you're going to make sure there are no firearms in the home. Do you understand that?
Yes.
Do you have any reason to believe that she has access to firearms other than the ones that you own?
No.
Ms. Bromley, I'm going to order that you not own, possess, control, or otherwise have any firearms or weapons while this case is pending. Given the fact that you're 9 months pregnant, given the fact that the alleged victim is here indicating that effectively this is a misunderstanding about what took place, again, I'm going to let you go back home, but please understand, Ms. Bromley, if there are any allegations that you violated my conditions of release, you should assume, number one, that I'm going to sign a warrant for your arrest. Number two, you should not assume that you'll get back out of jail if there's a violation of any of the conditions of release. Given the fact that you're 9 months pregnant, it's probably very difficult for you to care for your child if you end up violating and coming back to jail. Does that make sense?
Yes, sir.
And please understand, I'm not going to require you to go back and live there. I'm going to let you go back. If you think it's not actually the wise decision, that's up to you. Do you understand?
Yes, sir.
Do we have court dates for Ms. Bromley?
On demand.
Next, I have Stephen Stone.
I can leave now.
You may. Good luck to you, sir.
PD is approved, Your Honor, for Mr. Stone.
Okay.
Yes, sir.
All right, sir. You have two matters before the court today. The first is your new arrest for possession of cocaine and possession or use of drug paraphernalia. I do find probable cause for those offenses. In those cases, I'm going to set bond on count one in the amount of $5,000, and I'll order pretrial release. If you post that bond, your conditions of release are weekly check-ins, do not possess any alcohol or illegal drugs, be subject to random drug testing.
Yes, sir.
For those, count two, the bond is $100 and pretrial release with the same conditions. Your other problem is that you were out on bond when
Yes, sir.
this took place in 2018 MM4311. In that case, I'm going to revoke your bond and hold you on a no bond status pending disposition of that case, or if the division judge assigned to the case decides to let you back out.
So wait, can I ask you what's going on then?
You got arrested for a new offense. I
Yes,
set
sir.
bond in that because I'm required to give you bond by law.
Yes, sir.
You were on bond when
Yes, sir.
this probable cause existed. In that case, I'm revoking your bond. In that case, you don't have a bond unless you get in front of your assigned judge in county court and that judge agrees to give you a bond.
Yes,
But
sir.
at this point, you're on a no bond status on that case. Your next court dates are as follows.
On
So-
demand.
I don't.
Okay. You can talk to the public defender. Okay.
There, that's all.
All right. Next is Matthew Shingler.
You're bonded, Judge.
Okay. Next is Marilyn Torres.
PD approved.
Good afternoon, ma'am. You've been arrested and charged with 2 counts of battery, acts of, at least one of those is an act of domestic violence. We have a witness present. Let's go ahead and swear that witness in.
Sir, can you please raise your right hand? Do you solemnly swear and affirm that the testimony you're about to give on this case to be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, tell me your name.
Victor Martinez?
How are you? Madam Defendant, are you okay?
Yes.
Are you sure?
That's my son, yes.
Okay. If you need me to reset your case to tomorrow, I'm happy to do that for you.
It's okay.
Sir, how are you related to the defendant? And we're here today for first appearance. We're not here for trial of the case today. This is when I set conditions of release. Anything you want to tell me before I decide what conditions of release to put in effect?
This is my first time ever going through this with my mother, you know. She done what I did to her, she did to me, but it never got this serious. Never got this serious this far. She's a very independent woman. She raised 3 children herself. You know, you can't blame somebody from their past. But I love my mother no matter what, and what we go through. Still gonna have that love for her.
All right. Well, sir, whether you love the defendant or not isn't really the legal question for the court. The legal question for the court is what conditions of release are appropriate. Let me ask you this. 398 Greenwich Court, is that a home, apartment, or something else? Who owns that home? Okay.
Maryland Tours.
And do you have any place to live other than that home? Okay. Who pays the bills to pay the mortgage or rent or whatever for that home? Okay. Do you work?
Not currently.
Okay. State, do you want to ask any questions of the victim while he's here?
No, Your Honor.
Your Honor, may I ask a question?
Go ahead.
I'm sorry, I don't have the police report right in front of me. Sir, if an incident like this might happen again, would you be afraid to call the police?
No.
Are you afraid of your mother?
No.
So you'd feel comfortable living with her?
Of course.
Okay. I have no further questions, Your Honor.
Sir, let me ask you this. Based on the way this report is written, it appears that there was also an issue, and maybe the whole issue was the fact that your girlfriend was staying with you in your bedroom? All right. So, do you anticipate that your girlfriend is going to continue to stay at the home?
Of course not.
All right, ma'am, here's what we're going to do. I'm going to release you through the pretrial release program with the following conditions. I'm going to order you have no hostile contact with your son, Victor. I'm going to order that you do weekly check-ins with pretrial release. I'm going to order that you not consume any alcohol or illegal drugs while this case is pending. I'm going to order that you have no contact whatsoever with the second identified victim, Thandia. I'm not sure what Thandia's last name is, okay? I'm going to order you have no hostile contact with your son. That means no yelling, no screaming, no pushing, no shoving. If he's making decisions that you disagree with as his mother, I think your options are to explain to him he's got to find a different roof to live under, not any other way of addressing the situation. Does that make sense?
Yes.
Victor, if you bring your girlfriend over to the house, it's going to put your mom in a situation where she's violating conditions of release, which means she could be arrested and taken to jail. So you probably need to figure out a different way to spend time with your girlfriend other than bring her around your mom. Does that make sense? I'll also order as a condition of pretrial release that you not possess any firearms or weapons. State anything else that you're going to ask for.
RUA, no drugs and alcohol.
I think I already said no drugs and no alcohol. I will order that you be subject to random drug testing at your own expense while this case is pending. Anything else, State?
No, Your Honor.
All right, that's the order of the court. Do we have dates for Ms. Torres?
Yes, Your Honor. Next court date will be April 23rd, 8:15, courtroom 4A.
Thank you.
And last, I have a defendant who originally came in as John Doe. It now appears to be Kyle Wharton.
And we have no application for this gentleman.
Okay. So,
Your Honor,
go ahead.
we'd ask that he be released on his own recognizance. I did argue probable cause on this case yesterday, and as of the police report stands now, there's still no probable cause, so we would ask that he be released on his own recognizance.
What's lacking in the probable cause?
There are no specific details as to the incident that occurred. All it is a legal conclusion stating that a battery occurred, basically.
State, do you have any additional information in regards to this case?
Sorry to cut you off, Judge. The state does not have any additional information. When I got the packet, I reached out to the arresting officer via email and have not received a response.
Okay. What are you asking me to do, State?
Your Honor, the state would argue that within the four corners of the arrest affidavit, the elements of the charged offense are spelled out. So the state would ask that the court find probable cause. And this case has already been subject to 124-hour reset, Judge.
Hold on.
Okay.
All right, argument by the public defender in opposition?
Yes, Your Honor. Again, the police report only states the legal conclusion. There's no information about what my client did or the circumstance surrounding the actual charges. And for that reason, we'd ask for him to be released on his own recognizance. As the state attorney indicated, this has already been reset once, and unless they can prove extraordinary circumstance, then this could not be reset again, Your Honor.
How do I release him on his own recognizance when we don't know who he is?
Your Honor, his identity was verified by fingerprints. At least that was the indication by PTR yesterday. His name is Kyle Horton, and
Corrections, are you concurring that you are comfortable that he's Kyle Horton?
Yes, Judge. The FBI came back with a positive match, like fingerprints. So it is Kyle Horton.
All right. State, the charging affidavit could be read in several different ways. It could be read as a statement of facts, or it could be read as simply a boilerplate conclusion that law enforcement oftentimes puts at the beginning of their affidavits to explain to the court what it is they believe the evidence shows. Then it's normally followed by a recitation. I think if it's open to being read either way, I have to read it in favor of the defendant. I'm also concerned, it's an open question in my mind, if one judge has already said no PC and reset it, whether I'm allowed to reweigh the decision that this doesn't constitute PC. I don't know the answer to that. No one's provided me a case on point on that issue. So, under these facts and this procedural history, I'm going to order that Mr. Horton be released on his own recognizance. Sir, that means it's your obligation to make sure the clerk of the court has a correct and accurate address for you, because if the state attorney does charge you with the crime and they can't get you in to court, then a warrant's going to be issued and you're going to end up back in the Osceola County Jail proceeding through this case. Do you understand?
Yes.
All right. Tell me your name for the record.
Kyle Horton,
Tell me your date of birth for the record.
4/13/98.
All right. That's your the court in regards to Mr. Horton.
Thank you, Your Honor.
Next court date on demand.
I am out of paper, so that leads me to believe that we've handled all the cases. Is that correct?
No, Judge, we still have Varys Ryan.
Yes, Your Honor.
Yes. It looks like we thought that he had bonded prior, but he didn't. I apologize for that,
Okay.
and I'm gonna print the arrest report, Your Honor.
All right.
Ryan Veras.
Jeremy Vale, whatever.
A couple people had bonded, so that may be one of them. She can file it with the clerk's office. Yes, sir.
Do you have a Jeremy? I don't have it either. Might be from yesterday weekend ice. I know it's not wanting to print. I'm gonna try.
Does anybody else have a copy of the arrest affidavit in this case?
Right here, Judge.
I apologize for
Hey,
that.
Judge, I have something to say about Mr. No, the one that had the immigration detainer. Because I remember now seeing on the corrections, yes. In the corrections case management, his bonds were paid in the morning, but then the bondsman came and retrieved those bonds when they found out that he had a immigration detainer.
I can have them bring him over here.
Why don't we just reset him for tomorrow, because I don't think he's going anywhere at this point in time.
Right.
No, he's not.
Correct,
Okay.
Your Honor.
All right, let's call up Ryan Vares, or Varies.
This person, they're scheduled for arraignment on April the 3rd, 8:30.
Afternoon, sir. Tell me your name.
Ryan Veras.
Sir, you've got two charges before the court. The first is providing a false name or ID by arrestee. The second is resisting arrest without violence.
And Mr. Veras, for the record, Your Honor, was denied above guidelines.
Okay. Sir, you don't qualify for the services of the public defender, so you're going to have to end up making your own arrangements to get an attorney in this matter. Just give me one moment. All right, so I find probable cause for each of the offenses. I'm going to stay your bond on false name or ID by arrestee at $500 and stay your bond on resist arrest without violence at $250. Do we have future court dates for him?
Yes, Your Honor. If still in jail, it will be April the 4th, if out, April 22nd in courtroom 4A.
The defendant has a second case, Judge. I don't know.
That's what I'm trying to ascertain is...
It's an on-view VOP for...
Sir, it appears that you were on probation at the time of this offense. Have they actually filed an affidavit of violation yet? Or is it just...
There's a detainer for Brevard County, Judge. It seems that they want him back in Brevard.
Okay, the VOP is out of Brevard County?
Yes, Judge.
Okay. Sir, there's a VOP out of Brevard County for you. They put a detainer on you. You'll remain in the Osceola County Jail pending Brevard County authorities to pick you up and return you there to resolve your violation of probation. You gave him his dates here?
Yes, Your Honor.
All right, that's the order of court in regards to Mr. Varies.
That was my date.
I believe that's everyone, Your Honor.
All right.
Thank you. Have a good week.
Have a wonderful day.
You too.
Judge, thank you.
Okay. I'm getting ready to run downstairs.
They're waiting.
I know they are. Do we know if all the jurors are back?
I don't know yet, sir. Okay. I'll go down there right now.
Good afternoon, everyone.
Okay.
Good afternoon.
Hi, how are you?
That's the weekend, right?
And Judge, anytime you need criminal histories, just let me know.
Okay. I appreciate that.
problem.
It depends on the cases. A lot of times,
Some other very just,
the facts kind of speak for themselves, and I get a
Alright.
pretty good sense of what I'm going to do. Other times, their history becomes more important. So.
Well, we're gonna go downstairs too.
You guys don't want to hang around the mean judge? Again, it just depends on who you ask. I suspect Mr. Houston will tell you that I'm a horrible, terrible person. He'll tell you that for the next 30 years of his life.
Everybody wants to come work in our courtroom.
They don't want to?
They do.
Oh, they do.
Well, there's this old saying, allegedly Winston Churchill said it, but, sometimes people just say everything was said by Winston Churchill, but he said once, if you're going to kill a man, you can at least smile at him. So, my theory is we all have jobs to do.
Yeah.
We should try to be as stress-free as possible.
I agree.
And
Sometimes the job involves telling people bad news.
I do agree with that.
Okay. Thank you.
All right, if council please announce their names for the record.
Good morning, Your Honor. My name is Barrington Irving on behalf of the state of Florida.
Good morning, Your Honor. My name is Fernando Perez on behalf of the Office of the Public Defender.
All right. The first files I have are James Smith. Your name, sir?
Nathan Smith.
All right, sir, you've got a couple of things here. Burglary of an occupied structure, bond $5,000. Petty theft, bond $250. And another case involving disorderly intoxication, bond $250. So it looks like the total bonds would be $5,500. Now, sir, do you want me to appoint a lawyer for you?
Sure, yes, sir.
The Office of the Public Defender is appointed. Division 10 on the felony case and A on the misdemeanor. Your name, sir?
Yeah, 4 acres.
All right, sir. Let's see. Sir, you have a Volusia County warrant. Apparently, your bond totals $575. Looks like it's a battery charge. You'll be transported, sir, to Volusia County to answer to the charges there. William McLeish?
Yes, sir.
All right, sir, you've got a set of charges here. Retail, petty theft, bond $500, resisting an officer without violence, bond $100. Do you want me to appoint a lawyer for you, sir?
I'm already been appointed.
I couldn't hear you, sir. The
Already
question
been-
is,
already been.
do you want me to appoint a lawyer for you?
I think I already got a public defender.
All right. Public defenders are lawyers. The Office of the Public Defender would be appointed in regard to this case.
Oh, yes, sir. Yes, sir.
So your bonds totals $600.
He is an open case. He's out of on the case.
He's out on bond in this case. You want to take any action on it or don't?
Let's see. It's the same charges, isn't it? Retail theft and resisting without. On that, the new one?
This is petty theft and resisting without. But this is, they didn't print it out for you. Hold on. The other charges are robbery and resisting officer without violence.
All right, the bond on which you are released at this time, not the new case, but the one on which you're released, is revoked. All right, next case is that of Kenneth Hardy. All right, your name, sir?
Kenneth Hardy.
Mr. Hardy, you've got a charge here of disorderly conduct. Your bond at this time is $250. Do you want me to appoint a lawyer for you?
Yes.
Public Defenders appointed, Division A, offer from the state.
One second, Your Honor. Yes, 1 second as well, Your Honor. I don't believe this man was listed in the move-ups. Oh, I'm sorry, I'm looking at felonies, that's silly. There we go. City and county ordinances.
does not have an offer, Your Honor.
All right. All right, that's it then.
How long am I going to be here on that?
We haven't hit a court yet, so you want to get that about that week. So you want definitely.
I don't have it. The judge, can he give me time served?
All right, the next file is that of, looks like Adolfo Salinas Sober Bar. Sir, what is your name, please?
Adolfo Salinas Sobalbarro.
All right. Sir, you've got an open container charge. Do you want me to appoint a lawyer for you?
Yes.
Yes, Your Honor.
All right, public defender's appointed, offer from the state.
Your Honor, the state has no offer on this case as well.
All right. If a plea of guilty or no contest is entered, the court would sentence this gentleman to 5 days, credit for 2 days, time served, and court costs totaling $273 payable within a year, adjudication of guilt.
Okay.
Is he a brand new state?
My client would like to accept the court's offer at this time and enter a plea of no contest.
All right. There's a factual basis stated here in the arrest affidavit. The plea would be accepted, and that penalty would be imposed, adjudication, and 5 days credit for 2, and the court costs as previously announced. Yeah, you're right. All right, the next file is that of Kenneth Jeter. Is that you, sir?
Kenneth Jeter.
All right. Mr. Jeter, you've got a charge here of trespass on property after warning. Is there any offer from the state on this case?
They use this.
No, Your Honor.
All right. Office of the Public Defender is appointed to represent you. If a plea were to be entered, there would be an adjudication, 5 days Orange County Jail, credit for 2 days time served, court costs $323 payable within 1 year.
I'm not saying that. I didn't do that. I'm not touching nothing. Simon.
One moment. Apologies, Your Honor, sir. Your Honor, apologies. Would a possible apologies? Yes. So that's just what we're looking at right now, sir. I'm going to say that. Be here 3 days, sir.
No, I'm letting go. All the time. Let me go. All the
All right, if there's no decision by the defendant at this time, we're going to move on.
Okay, good luck, sir. Wait, hold on.
No, he said hold on. He said hold on.
There you go, that's our paperwork.
Your Honor, the bond was set in this case for how much?
Sorry, sir, good luck, sir.
500.
Thank you.
Good luck, sir.
And the PD's appointed, correct?
Yes.
Yes.
Mr. Barrington. Okay.
Linda Nelson. Your name, please.
Linda Nelson.
All right, Ms. Nelson, you've got a charge of trespass on property after warning. Do you want me to appoint a lawyer for you?
Public defender.
Public defender's appointed, Division A, $500 bond. Now, on this case, is there any input from the state?
Your Honor, the state would be prepared to offer 5 days in jail, no return to the scene, and court costs.
Would the state, right now, would the state be willing to consider a credit time served offer? My client does not seem to have an extensive history, and nor does he seem a particular danger to the community.
How much credit does
2 days.
3 days?
2 days.
2 days.
Well, she's been in here 2 days, right? Okay, she's been in
I
here.
want to plead guilty to the charge.
Your Honor, the state will offer 2 days. We'll do a credit time serve offer.
Kill me out there.
Ma'am, we have an offer from the state. It's adjudication, credit time served. You will get out today.
I don't want to be out there around those people. They out there trying to kill me.
Okay, so you don't want to accept the offer?
No.
Okay.
All right.
There's a $500 bond. Okay, wait, hold on. Let me give her her paperwork. There you go. Good luck, ma'am.
Mario Aponte. Right, reset. The next file then is that of Babalu Jakeshan, if I pronounce that correctly.
Jackie Sean Babulao.
All right, sir, you have a set of charges here. Burglary of a structure, bond 5,000. Petty theft, bond 100. Criminal mischief, more than 200, less than $1,000, bond $100. And dealing in stolen property, bond $150. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 17.
Serious charges, so you're going to get in touch with our office when you can. Okay, so I cannot do anything at this time. Well, you can't, but you'll have to have them, or you can call your police now. Go with that. You do. 5,000, now from a bit, bond, like 500.
In total?
No, it'd be 500 for the top first one. But good luck, sir.
All right, next file is that of David Benson. There are two charges here, possession of cocaine and no valid driver's license. Sir, do you want me, are you Mr. Benson?
Yes, sir.
Do you want me to appoint a lawyer for you?
Yes, sir.
Public Defender's appointed, Division 16 on the cocaine case, and Division A on the no valid.
You said Division 80 on no valid?
Say again?
You said Division 80 on no valid?
No, Division A is an apple.
Hey, thank you.
She qualifies for PTR.
And what are the charges again?
Possession of cocaine and no valid driver's license.
Now, when they qualify for PTR, does the judge always grant that? All right, even though he qualifies for PTR, that qualification will not be considered at this time by the court, so the bonds remain at a total of $1,500.
Your Honor, if the defense may be heard, my client does not have an extensive history, and the facts of the case show it was, by the estimates of the officer, allegedly a small baggie. Would the court be willing to reconsider in light of the fact that my client has no extensive history and the facts of the case don't rise to a level to completely discount PTR?
Well, in regard to the cocaine case, then the court would reduce the bond to $500 as opposed to $1,000, and the other bond remains the same. And that was $500.
Understood.
Okay. All right, Todd Brule.
Yes, sir.
Sir, you have a set of charges here. Battery on a person 65 years of age or older. You're in a no bond status in regard to that. And a charge of simple battery on which the charge is $500 with conditions. No contact directly or indirectly with the victim or co-defendant witnesses. Maintain a separate residence. Don't return to the scene of the offense. Don't possess or consume any alcohol or illegal drugs. Don't possess any weapons or firearms. So, sir, do you want me to appoint a lawyer for you?
Yes, please.
All right, Division 19.
Apologies, Your Honor. Did we say the bond as the battery, and did we set no bond as to the battery on the alleged battery on person of 65 age or older?
Correct.
Thank you, Your Honor, for the clarification. Here. Alright, so we're here. You're on. You can't bond that at the moment. So that's what we're doing right now. I wish you good luck. Please get in touch with us when you can. Thank you.
All right, next case is that of Kenyon Bryant. What is your name, sir?
Kenyon Bryant.
All right, sir, several things here. A warrant here for robbery by sudden snatching. Your bond there is $5,000. You're released on a possession of cocaine within 1,000 feet of a place of worship, and that bond at this time would be revoked, and I believe that's all. So Division 10 on the new case.
You're on that case, sir. So we're going to see what happens there. But if you have any questions on that, you're going to want to talk with the public defender that you assigned. Yes, at the moment you can't bond out. So you're going to get in touch with our office when you can. This is going to be an ongoing matter. I want to wish you good luck.
Thank you, sir.
All right, your name, sir?
Isaiah Cordero.
Mr. Cordero, sir, you've got a warrant here that was issued for failure to appear on possession of methamphetamine, possession of 20 grams or less of cannabis, and possession of drug paraphernalia. And it states here you failed to appear, so you're in a no bond status. Now, do you want me to appoint a lawyer? Was the public defender previously appointed?
Yeah, public defender.
All right, public defender is appointed, if not reappointed, Division 16.
That may not be an immediate excuse upon no jurisdiction. So we're going to, if you want to get with us, if that is not the most.
I was incarcerated
All right, next file is that of Kareem Ford.
Yes, sir.
All right, sir, two things here. Failure to appear capious on a delivery of cocaine case. You're in a no bond status in regard to that. And then, let's see. Yes, looks like you got another case from 2012, failure to appear. Both of these are Division 14. Appears to be two separate cases, two separate differing case numbers. Sir, was the public defender previously appointed?
Yes. Yes, sir.
All right. That's Division 14 on both. All right, the next file is that of Joseph Hill. Is that you, sir?
Yes, sir.
All right, Mr. Hill. Sir, you've got a charge of possession of cocaine on which your bond is $1,000. I don't have any financial affidavit filled out for you. Does the public defender know if you've had prior representation?
I do not know at this time, Your Honor. Not in this current case. I do not believe he has a public defender assigned to this case.
Well, let's see. Mr. Hill, are you intending to hire an attorney?
No.
Do you want me to consider appointing the office of the public defender at this time?
Correct.
All right, public defender is appointed, Division 12.
Which one applies for PTR?
All right, so ordered.
Call what number?
This one.
Today?
Judge. Just break.
Yes.
Qualifies for PTR.
Yes.
Okay.
Granted?
Okay.
All right,
Okay.
Michael Hoyman is the next case. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Burglary of a structure, bond $3,500. Grand theft, third degree, more than $300, less than $5,000, bond $150. Dealing in stolen property, bond $150. Receiving money from a pawnbroker with false verification, bond $150. And criminal mischief, more than $200, less than $1,000, bond is $100. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 14.
Yes, we can ask. I believe they are just about all the documents. Sorry. Now, I have an appointment with the defender, and that's good. I have all the documents. So that'd be what we can do. We have a precedent that we're possible. I think it's very possible.
All right.
I don't know if you'd like, sir.
Bless you. All right, next file is that of Mark Jokin.
He bought it, Your Honor.
All right. Then Ronald Meekins.
Yes, sir.
All right, sir, a set of charges here. petty theft with 2 prior convictions, 2 counts of that. Your bond is $1,000 count 1, $150 count 2. Do you want me to appoint a lawyer for you, sir?
Public defender, sir.
Say again?
Public defender.
All right, Office of the Public Defender is appointed. That's Division 12.
Your Honor, Wayne Malier is behavior. Malier.
Say again?
Wayne Malier is behavior.
All right, reset. All right, next file I have then is that of James Miller. Is that you, sir?
Yes, it is.
All right, sir, 3 cases apparently. Retail theft, bond $2,500. Resisting a merchant, bond $100. And then another case of retail theft, more than $300. Your bond is $1,000 in regard to that allegation. And lastly, another retail theft, more than $300, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Yes.
All right, we have Division 15, the public defender's appointed. Division 15, first case. Division 11, second case, and 15 again on the third case. Next file I have is that of Kevin Morris.
Yes, Your Honor.
All right, Mr. Morris, you've got a set of charges here. Possession of heroin, bond $1,000, and possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Public defender, Your Honor. I believe I signed up for one already today also.
All right, the Office of the Public Defender is hereby appointed on these charges. That's Division 19.
He qualifies for PTR.
What do other judges deny PTR if they qualify? All right, bond or PTR on that case. Yes.
No, you're not RR. You should get out of bond. For that, I have to pay bond. But it's still not the case. So call us when you can.
All right, next file is that of Lentice Owens.
Yes, yes.
All right, sir, you've got a charge here of failure to report name or residence change as a sex offender. And at this time, you're in a no bond status. Do you want me to appoint a lawyer for you, sir?
He's asking if you want a public defender.
Office
Yes,
of the
yes, I
Public
would.
Defender is appointed Division 15. All right, the next file is that of Anthony.
Apologies, a moment to confer with records. Oh, yes. Apologies, Your Honor. Apparently my client does qualify for bond status. Would it be possible, considering he does not have an extensive history, if he could receive a bond today?
Judge, this is the type that comes in at no bond and gets set at IA.
That what?
The failure to report cases, they usually get a bond at IA.
All right. Well, I'm going to then set a bond at this time in the amount of $2,500.
Your Honor, the state asks that the bond be set at 5,000.
Let me look here. All right, having scanned the paperwork once again, the state's request to be granted be the higher amount, 1,000 or whatever. 5,000. All right, now the next file is that of Anthony Parton. Is that you, sir?
Yes, sir.
All right, sir. Several counts here, charges. Carrying a concealed weapon by a convicted felon, bond $5,000. And then possession of a firearm by a convicted felon, bond $150. And then looks like 5 counts of possession of ammunition by a convicted felon, bond $150 on each of those 5 counts. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, Division 22. All right, next file I have is that of Dion Richardson.
Apologies, Your Honor, I'm still getting my, stick with this bond at this time. I want to issue this. All right, hold on. You have an appointed public defender. Your Honor, may I have a moment to make a quick call to office? I appear to be running low on paperwork, and I need them to send a paralegal down with replacements.
All right.
Apologies. Just a moment to return to my desk. No, I didn't do. Actually, on second thought, Your Honor, let's do my, Mr. Richardson, and then I need to head upstairs for a brief 2-minute, a brief 2-minute absence to retrieve more paperwork. I
Well-
apologize, there was a lapse in my office's, workings. So,
What's the total amount of time you're requesting?
2 minutes.
What?
Or 1 moment, actually. If I may confer with a colleague of mine. Yes. Hi. Apologies. It appears that we're able to continue the proceedings.
All right. Then we will proceed. The next case is that of Dion Richardson.
Yes, sir.
All right, Mr. Richardson, sir, you've got a charge here of grand theft third degree of a motor vehicle. Bond in your case is $1,000. Do you want me to appoint a lawyer to represent you?
Yes, sir.
All right. Division 15, public defender appointed.
Sir. Am I eligible for ROR and anything? I mean, I'm a foot.
With our office and that we can't, this time we cannot do anything on it because of some fires here right now. So following up when you can, that is what we're currently dealing with, all right? I want to wish you good luck.
All right, next file is that of Emilio Serrano.
Yes, sir.
All right, sir, you've got a set of charges here. Burglary of a conveyance with assault or battery, no bond at this moment. Possession of a firearm in commission of a felony, no bond. Now, I don't have any application for criminal indigent status. Have you been previously represented by the Office of the Public Defender?
I choose go private.
Say again?
I'm gonna get my own attorney.
Oh, you're going to hire your own lawyer?
Yes.
All right. Well, for what it's worth, that's Division 15. All right, that concludes the case then. All right, next file is that of Logan Schumpert. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Possession of cocaine, bond $1,000. Possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defender is appointed, Division 20.
Records, I see that he didn't qualify for PTR, but the reason was additional notes. Was the detainer was it concerning the DNA retainer or?
Just wait for the APHIS to be completed, because he was interviewed.
Okay.
Just waiting on the APHIS to clear.
Okay, so APHIS hasn't arrived yet. All right, let's see here. Unfortunately, there's not much we can do at this time. Your Honor, my client has nothing in the way of a record. Would some leniency on the first count be possible at this time?
All right, what's the state's position, if any?
Your Honor, the state will leave it to your discretion.
All right. The bond on count 2 would be reduced to $100 from $500. Count 1 remains the same.
Thank you, Your Honor.
All right, the next file is that of James Starnes. All right, your name, please.
James Starnes, sir.
Mr. Starnes, you've got a charge here, failure to report name or residence change as a sex offender. The bond was set at $10,000 by the judge. Do you want me to appoint a lawyer for you, sir?
Yes, sir, if you would, please.
All right, Office of the Public Defender is hereby appointed. Division 16.
All right.
Okay.
When the defendant doesn't fill out the financial affidavit, the judge's appointed the public defender.
All right, the next file is that of Justin Upton. Say again? All right, reset. All right, next case is that of Alan Waters.
TJ, sir, is my first name.
All right, T.J. Allen Waters, right?
Yes, sir. Good morning.
Okay, sir. All right, you've got a set of charges here: fleeing, attempting to elude a police officer, and driving while license suspended. Now, as to count one, you had been you did have that bond. It was originally set at no bond. At this time, the court is setting the bond at $10,000. As to count two, driving while license suspended, that bond is, instead of $2,500, is reduced to $250. Do you want me to appoint a lawyer for you, sir?
Please, sir.
All right, public defenders appointed, Division 22. All right, the next file I have is that of Jeffrey Ragg.
Yes, sir.
Sir, looks like a set. No, here. All right, you're out on bond on a charge of driving while license suspended or revoked with knowledge, second conviction. You have a new case here, bond of $2,500 on driving while license revoked as habitual offender.
Yes, sir.
So, looking at the history here, the bond on which you are released is revoked, and the new bond is the $2,500. Do you want me to appoint a lawyer, sir?
Yes, do that mean I can bond out today?
All right, that's Division 11.
So the original bond is $2,500 on the one you revoked, is the $2,500 too or no bond? On the one you revoked?
the new case is 2,500. The old one is revoked.
All right, we'll have to see about that then. So, don't worry. But, but so call us when you can about that. This is an ongoing case as well. So good luck. Okay. Bonding the driver's license is revoked. Since we're already out on bond, exactly. The charge revoked. So that means you can't bond out just yet. All right. Good luck, sir.
All right, next files are that of Bobby Wyrick.
Yes, sir.
Is that you, sir?
Yes, Your Honor.
All right, just a second. All right, Mr. Wyrick, 3 cases looks like. Grand theft, third degree of motor vehicle, bond $1,000. Resisting an officer without violence, bond $100. Then another case of failure to appear, and the judge in that case set you at a $500 bond. And then another failure to appear, and that bond likewise is set at $500. So we have $1,000, $100, $500, and $500. Now, sir, do you want me to appoint a lawyer for you, or do you already have a lawyer?
I would like for you to appoint me one, sir.
All right. Public defender appointed, Division 17 on the grand theft, et cetera. Division 85 on the first failure to appear, and 61 on the second failure to appear. All right, next file I have is that of Mikhail Briggs.
Yes, sir.
Sir, you've got a charge of open container. Bond is $250. I don't have any request for a lawyer from you. Is there any offer from the state on this case?
No, Your Honor.
All right, in regard to this, sir, if you wish to enter a plea of guilty or no contest, you'd be giving up, of course, your right to a trial, but the court would adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served, impose court costs, $223 payable within 1 year. You don't have to accept that offer. You may if you want.
I accept that, sir.
All right, so ordered. And I believe that's all then.
Yes, sir. Thank you, sir.
Was a public defender assigned to Mr. Briggs' case?
No, didn't fill out the request. All right, Paul Clark.
Behavior, Your Honor.
All right, reset.
Behavior reset?
Mel Dawson, or
Yes, sir.
Dawson? Is that you, sir?
Yes, sir.
All right, sir, you have a case here involving an allegation of disorderly conduct. Bond is $250. Do you want me to appoint a lawyer for you?
Yeah, you want a public defender.
All right, public defender is appointed, Division A. Now, in regard to this case, is there an offer from the state?
No, Your Honor.
All right. And what plea would be entered by the defense at this time?
Your Honor, my client does not have a very large history. I think for this particular charge, an adjudication with 2 days going towards a 5 days sentence would be more than sufficient to see justice done on this issue.
All right. If a plea of guilty or no contest were to be entered, the court would impose an adjudication, 3 days credit for 2 days time served, and court costs payable within 1 year.
Okay, so
273.
So you did not say you were ready for it. You're ready for it. Apologies, Your Honor. It appears that something has come up. The defense would like to thank Your Honor for the 5-day offer, but it appears that my client is trying to make a job interview in the morning, not to push matters further. Would a possible CTS be possible in this case, or would Your Honor rather stick with the original offer, which the defense would accept if it were?
All right, I'm sorry, the copier's going, I can't hear you. Speak up or yell or something.
There are important life circumstances for my client tomorrow morning I was only just made aware of. The defense, therefore, while thankful for the judge's offer, would like to ask if a possible CTS was issuable. If not, the offer as stands by the judge would be acceptable.
All right. What did he say? Did you hear?
Oh, okay, I'm sorry. 3 days.
I'll take it. Yes, sir.
All right. Apologies, Your Honor. It was a miscommunication.
Yes, sir. Yes, sir. I'm not.
Yes, 2 days, 2 days. Yeah, you get out. Because you were 2 days. I thought it was 5 days. Yes. There's okay. Apologies for the misunderstanding, Your Honor. One moment.
Offer 3 days.
3 days, 2 days served.
AG court costs.
AG court costs. Payable. Yes, and it today. Good luck, sir.
All right, the next file is that of Darnita Carter.
Yes.
Ma'am, you have a set of charges here. Possession of paraphernalia, bond $500. Loitering or prowling, bond $100. Securing another for prostitution, bond $100. So the total bonds are $700. Do you want me to appoint a lawyer for you?
Yes.
All right. Office of the Public Defender is appointed. That's Division A. All right, next file is that of Damian Jones. Is that you, sir? Sir, you have a set of charges here. Simple battery, bond $100. Resisting an officer without violence, 2 counts of that. $500 on one, $100 on the other for bond. Trespass on school grounds or facility, bond $100. And another case involving simple trespass, bond $100. Now, sir, do you want me to appoint a lawyer for you?
No, sir.
Office of the Public Defender is appointed. Now, let me add one other thing, and that is that you're out on bond on a petty theft and resisting without, and you were ROR'd. That ROR will stay just as it is. All right, now, so the Office of the Public Defender is appointed, and Division A.
Good luck.
All right, next file is that of Dennis Molenda. Is that you, sir?
Yes.
Mr. Molenda, you have a set of charges: petty theft, bond $100, trespass on property after warning, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. Public Defender is appointed, Division A. All right, the next file is
Apologies,
that,
Your Honor, apologies. I forgot to inquire if the state had an offer on this case.
No, the state does not have an offer because I do not have the history, and petty theft is an enhanceable crime.
I have the history right here if you would like me to give it to you. Permission to approach the state, Your Honor.
That's legacy project.
Yeah, all right. Yeah, the state would not be prepared to make an offer on this case.
okay,
That's our number. Please call me.
okay.
I want to wish you good luck.
All right, then that's all for the moment. Michael Silver,
Yes, sir.
is that you, sir?
Yes, sir.
All right, sir, you're released on a bond on a drug case. That bond is stayed. New cases or allegations, trespass in a conveyance, bond $100. Resisting an officer without violence, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender is appointed, Division A.
You can take any action on
No, stay.
Stay.
Apologies, Your Honor. I forgot to write down for the benefit of my client. Was the bond in the first appearance detainer or matter thereof revoked or
What do you want?
no? Okay, no action on the first appearance detainer. Apologies. Thank you, Your Honor.
Hmm.
All right. Should I take the paperwork, sir? I want to wish you goodbye. Please pause when you got a bond. You don't have to. Okay, this was stayed. No action. You have a bond there and a bond there. 100, 500. You can bond out, sir. Good luck, sir.
All right, next file I have is that of Rosalind Smith. Is that you, ma'am?
Yes.
Ms. Smith, you've got a charge here of trespass in a conveyance. Your bond is $500. Do you want me to appoint a lawyer for you?
I wasn't sure if I needed one or not, but I said yes.
Well, the Office of the Public Defender would be appointed Division A, and that will do it for the moment.
Qualified for PTR.
All right? So ordered.
So when I get out.
Get out today, no one, but it's on ongoing matter. Okay, good luck.
Thank you.
All right, next file I have is that of Wally St. Julian.
Yes, sir.
Sir, you've got a St. Lucie County case here, and let's see, failure to appear, and you're in a no bond status right now, so what happens is you would, let me look here. You would be transported to St. Lucie County to answer to the charges there.
You mind repeating that for me one more time, please?
All right, the only files I have left are the 33-day motions. Say again?
Bond hearings, you have some bond hearings in there.
Ah, all right. motion for release of defendant on ROR, parentheses, 33-day motion.
No, that's not him though, that's not the defendant, the guy that's. This is Mr. Gross. Yeah, you got quite a few there listed.
Oh,
I just didn't know what order it was coming out in, so, yeah. you have to look through that. That's not him.
gross. Two. All right, next files I have here, or rather file, is motion, the 33-day motion on William John Gross, input from the state.
No objection to RR, Your Honor.
All right. So ordered.
It says Vega is next. Is there something after Vega?
Thank you.
Yes, sir.
Good morning, Your Honor. Jace Thompson on behalf of the Office of the Public Defender. For the record, I wanted to, if at all possible, address the case of Todd Brule that you heard earlier. And that's case number 19 CF 3467.
He said from earlier.
What's the?
It's Gomez.
Todd Brule, Bruehl.
19 CF, you said?
19 CF 3467.
All right, that was a charge of battery on a person 65 years of age or older, no bond, and battery $500.
Yes, Your Honor. On the no bond, he is actually entitled to a bond under Florida law. The thing about it is this is a domestic violence case, and it was supposed to be heard in courtroom 2 and not courtroom 1. And I would ask for it to be transferred to courtroom 2, Your Honor.
All right, so ordered. And the order, if any, entered by this court in courtroom 1 would be vacated and set aside.
Thank you, Your Honor.
Next, we got Vega Gomez.
Your Honor.
All right, now, I've got, looks like 2 cases on Christopher Vega Gomez, cases ending in number 1297 and 1298.
Your Honor, if the defense may be heard at this time, it is the decision of the immediate representative of the Office of Public Defender to withdraw these motions and if to reinstate them then at a later date.
Can you hear what he's saying?
Speak into the mic, because we can't hear you.
Apologies, Your Honor. As I was saying, it is the decision of the immediate representative of the Office of Public Defender to withdraw the motions put forth before you today on behalf of Mr. Gomez at this time.
All right, so noted. And they're withdrawn. All right, now, I've got another file here. It's Elijah Kraft, case ending number 1739. So, input from the state.
Elijah
I only have a motion to withdraw before me. What was the other matter that we're tending to at this moment?
That's a 33-day.
Oh, okay, actually, Your Honor, before we commence the 33-day motion, I apologize. I must ask to hear a motion to withdraw from the Office of the Public Defender on behalf of one of our clients.
All right.
Let's see here. Would the judge like a copy of this motion presented to you at this time? All right.
All right.
In that case, I'm going to require either the assistance of records to print it out or to, or if you would like to look at it temporarily, so that I can go over it. All right. Apologies. Here you go.
These are the two on the wall. That's the motion.
All right, I assume there's no input from the state.
No, Your Honor.
So ordered, allowing withdrawal.
Thank you, Your Honor.
Next, we have
He's here for determination of counsel on this case.
All right, Ayub Abdulrahman, if I
Yes, sir.
pronounce that correctly.
Oh, you did wonderfully.
All right, now, sir, this is noted as a determination of counsel on a set of charges: arson of a conveyance, possession, manufacturing, transporting a firebomb. And I have now been furnished an application for criminal indigent status. Do you want me to appoint a lawyer for you?
Yes, sir.
All right. Office of the Public Defender would be hereby appointed. You qualify according to the paperwork here. And that's Division 11.
Your Honor, if I may receive clarification, what was the current bond status of the public defender's newest client?
What was the what?
What was the bond status?
5,000, count 1, 150, count 2.
5,150. Okay.
He's here for a plea. He
All right,
has
we're gonna have to see
38
what we
days.
can do, sir. Okay, I don't have your case before me right now, so I can't skip the search. All right. What's your name? Fernando, but I'll be standing the post here. You'll be working with one of our guys now. Thank you. All right, good luck, sir. Okay, thank you. Thank you.
All right, I have a file here on Mark Kane, and it states plea that he has 38 days credit. Any input from the public defender?
Was Mr. Kane assigned a public defender for his case?
Look on the second page. Yes. He was. Yes.
Yes. Public defender was appointed by Judge Wish.
A moment.
It was originally disorderly conduct. Has 38 days credit.
I apologize, Your Honor. I don't seem to have his paperwork. Was he a reset?
Hmm?
No, he was an add-on docket.
Oh.
Add-on docket.
I see. Barrington, do you have Mr. Kane's complaint sheet on you?
Is it Antonio?
Mark Kane. One moment, let me pull up my laptop. All right, actually, apologies. If we may, the account was disorderly conduct originally, right?
Aye.
Yes.
Okay. In that case, if he has been appointed a public defender, then would an adjudication with credit time served be possible at this time if my client were to make a plea to the bench?
This is for disorderly conduct for Mark Kane. We do have an offer. The offer is a withhold $223 in court, $223 court costs, and a $10 filing fee on the disorderly conduct charge.
The withhold to go to the 13th. Can I tell?
This is on PTO.
Good. Apologies for the mix-up, sir. All right, thank you, Mr. Barrington.
The 223s are fine.
My client would like to accept the state's offer at this time and plead no contest.
All right, and for plea purposes only, stipulate to a factual basis. What? Hmm? Is this Kane?
I support the factual basis. I think that's the factual basis.
Yes. Apologies, a moment to confer with state.
All right, there's
Oh, I see, yes, that was the problem. Okay.
notes on the paperwork I have, says plea 38 days.
I see, yes. Plea, motion, 38 days. Okay, yes, I have that now. One moment. Okay. Okay, so we're not stipulating to the factual basis, we just to take the offer from the state. At this time, Your Honor.
Stipulate to the factual basis for the purpose just of the plea.
Okay.
Yeah, just for the purpose of the plea.
Okay, apologies, Your Honor. We would stipulate to the facts of the case just for the purposes of the plea, Your Honor.
All right. And let's see, for the record, in case it wasn't previously stated, case number 2019 MO 239. And the note, once again on the file, says be a plea with 38 days. And it looks like, let's see, arrest date was February 3rd. So that's at least 38 days, I believe.
Your Honor, and just for record purposes, the offer is a withhold court cost, $10 filing fee, and credit time served for the days that he spent in OCJ.
All right. And is that you guys' name?
Yes, just get in touch with the officer and you can on the other matter.
Yeah.
All right, good luck, sir. Apologies for the discrepancies, Your Honor.
Let's see. Now, I have another 33-day motion here. Elijah Kraft, case ending in number 1739. State.
Your Honor, denied for Elijah Kraft, sent to clerk file. It was sent to clerk filing. ID is 86258948.
All right,
So the state asks that this motion be denied because this case was sent to the clerk, and the filing ID is 86258948.
all right. So ordered, denied.
That's the rest of them.
So all of these are.
All 33, yeah.
All right, now I've got a pile of 33-day motions here. Ryan Beamer, 18, CF 18342.
Your Honor, the state is also asking that this motion be denied. It was filed 3/12. It was filed yesterday, Your Honor.
All right, so ordered. Then another case here, Christian Cutright, case ending in number 1208.
Your Honor, the state is also asking that this motion be denied. It was filed in the filing ID. It was filed yesterday. The filing ID is 86238102.
All right. Next file is that of Lawrence Johnson, case ending in number 1161.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. The filing ID is 86254763.
All right. Sarah Alicia, case ending in number 1899.
Your Honor, the state is asking that this motion be denied as well. The info was filed on 3/11. Request for administrative transfer filed. Copies provided.
All right, so ordered. Elijah Kraft, case ending in number 16857.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. Sent to the clerk. The filing ID is 86258948.
All right, so ordered. Molly Fondario.
One moment, Your Honor. I think defense counsel has one.
Request from defense, I'm trying to write down the IDs for paperwork purposes back at the office. Could you read the IDs a bit more slowly
All right, that's fine.
for all denials?
All right.
Now, the next case I have is that of Molly Fondario, case ending in number 2001.
Your Honor, the state is asking that this motion be granted. It was sent to the clerk. The filing ID is 86240999. Yeah, that's it for that one.
So I want to make sure I understand. You're requesting the court grant or deny?
Granted, there was a notice of non-filing sent to the
Okay,
clerk.
all right, good enough.
Yeah, that was a mess up, Your Honor. I'm sorry.
All right, Karen Utter, case ending in number 1836.
Your Honor, the state's action that this motion be granted. There was a notice of non-filing sent to the clerk yesterday. The
All
filing
right.
ID is 862777806.
All right, so ordered. Molly Fondario, case ending in number 2002.
All right, Your Honor, the state is also asking that this motion be granted. There's a notice of non-filing yesterday on
All right.
3/12.
Daquan Walker, case ending in number 2009.
Your Honor, the state is asking that this motion be granted. There was a notice of non-filing yesterday as well.
So ordered. All right, McHenry Francois, case ending in number 1973.
Your Honor, the state is asking that this motion be denied. Yesterday, there was a request for administrative transfer filed.
All right, so ordered. Rachel Brown, case ending in number 18004.
Your Honor, the state is asking that this motion be denied. This case was filed yesterday. The filing ID is 862729991.
All right. Granted. All right, now, we're gonna take a recess. How long does the public defender request?
All my cases have already been completed. I don't believe there's anything complicated coming up. 35 minutes, if possible, for staff to prepare our clients.
35 minutes?
Yes, Your Honor.
All right, 35 minutes it is by my watch. That would be 20 after 11. But,
Let's make it 11:30, please.
all right, Madam Clerk, she wants to make it 11:30, so 11:30 it will be.
Thank you, Your Honor.
Court's in recess till then.
Just when you be ready. Oh, we did that.
Yeah. All right, if council would please announce their names for the record.
Barrington Irvin, on behalf of the state of Florida.
Fernando Perez, on behalf of the Office of the Public Defender.
All right. Thank you. Now, all right, your name, please?
Tashari Adderley.
Ms. Adderley, you've got a charge here of obtaining controlled substance by forgery. Your bond at this time is $1,000. Now, do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is hereby appointed, and that is Division 11.
Your Honor, if the defense may be heard before proceeding, my client, Miss Adderley, has nothing in the way of a track record. Would it be possible to reduce her bond at this time?
All right, let me review this again. The state have any position in regard to that?
Your Honor, the state will leave it to your discretion.
All right, in regard to this, according to the arrest affidavit, this is one of a number of similar events. So the court feels it would be appropriate to leave the bond as was announced. All right, your name, sir?
Alvarez Perez.
All right, sir, you've got a capias here for a set of charges, failure to appear, no bond, and two other failures to appear, no bond. So the judge on that case entered that order. Now, all right, public defender was previously appointed, Division 16. All right, next file is that of Jonathan Black. Is that you, sir?
Yes, Your Honor.
All right, sir, you've got a couple of cases here. Purchase of cocaine, bond 1,000. Possession of cocaine within 1,000 feet of a bus stop, bond 500. Tampering with physical evidence, bond 500. Possession of drug paraphernalia, bond $250. And you have yet a second charge, possession of alprazolam, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Please.
All right, sir. In regard to the first set of allegations, cocaine, et cetera, that's Division 11. And alprazolam is Division 16.
Okay.
All right, sir.
Thank you.
Good luck, sir. Call that number when you can.
All right, Horatio Brock.
It's Orisha Brooks.
There was a typo, Your Honor.
It was messed up.
All right. I did not understand what the individual said. What is your name?
My name is Orisha Brooks.
Okay, Brooks. All right, ma'am, you've got a charge here, attempted aggravated battery with a deadly weapon. And in regard to this charge, do you want me to appoint a lawyer to represent you?
Yes.
All right, the Office of the Public Defender is hereby appointed. That's Division 12.
Yes. Good luck, ma'am. Yes, sort of.
All right, the next file is that of Cosby Daniels. Is that you, sir?
Yes, sir.
All right, sir. You've got a set of new charges here. Count 1, possession of firearm by convicted felon. Count 2, possession of ammunition by convicted felon. The first count is $4,000 bond. Second is $150. Possession of oxycodone, bond $150. Possession of alprazolam, bond $150. Possession of tetracannabinoids or something like that, bond $150. Possession of cannabis, bond $100. Possession of paraphernalia, bond $100. Now, in regard to this new case here, do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed. Need to look at one other thing here. All right, now, you're out on bond on possession of firearm by convicted felon, et cetera. And that bond, because of the new charges, is hereby revoked. And public defender is appointed, as I say, and Division 17. All right, Esteban Duran,
Yes, sir.
is that you, sir?
Yes, sir.
All right, sir. There's several charges here. Trafficking in fentanyl, 4 grams or more, bond $250,000. Possession of ammunition by a convicted felon, there's 3 counts of that, bond $150 each. Possession of controlled substance with intent to sell, bond $150. Resisting an officer without violence, bond $100. And possession of paraphernalia, bond $100. Now, in regard to these allegations, I don't see that you've filed the application for criminal indigent status. Can the Office of the Public Defender advise me as to whether you've got present or former representation?
Your Honor, I did not see if he was being represented by the public defender at this time, and certainly not on these immediate charges.
All right. Well, I'm still looking through all this paperwork for one. No, there is none. That's Division 22, and upon application for appointment of counsel and qualification, a lawyer can be appointed. All right, Candy Glenn.
Oh, apologies, Your Honor. If I may, it appears that Mr. Duran has been incarcerated 3 years prior and is now currently unemployed. He should certainly have indigency status. All right. Actually, sorry. Apologies, Your Honor. Okay, so you're gonna have to apply for a public defender's office.
I'm not going to private attorney.
Okay, so you're gonna hire private?
Yes, sir.
Okay, so disregard that phone number and just, these are your bonds, you have to worry about. I wanna wish you good luck. Don't talk to, oh wait, actually, hold on. With that, don't talk to anyone.
Your
don't know, wait, what was the division on that case? Was the public defender appointed?
No, public defender was appointed. He plans on hiring a private.
All right, and it was sent to division.
I did not hear the division.
Your Honor, Duran Esteban Jesus. What division was that case sent to?
22.
22, thank you.
All right. That's it for the moment. Candy Glenn. Is that you, ma'am?
Yes.
All right, ma'am, you've got a new set of charges here. Possession of cocaine, bond 1,000. Possession of methamphetamine or methylene, bond 150. Possession of cannabis, bond $100. And you are released on bond at this time, and that bond would be stayed. And you want me to appoint a lawyer, correct?
Yes.
Office of the Public Defender is appointed, and this new case is Division 11.
Yes, it appears so. So you can't bond out the other simply, card, so you can bond out till the other county picks up.
So, I can't burn out till the other county pick me up.
Okay, so,
Could I burn out now and then the other county pick me up? I gotta burn out first before the county pick me up.
you have a hold for Lake County.
Well, that's what I'm saying.
All right, so if they have bonds set up for you on those charges, then you can bond out on those.
So how would I know that?
I think it would be provided to you. Hold on. Apologies, records. My client apparently has a hold for Lake County. Would she be made aware of any bonds that Lake County Division posted for her? Okay, you'll be made aware as this goes on. Bond number is in. Okay, all right. You can't, all right, in that case, then you put a zero. Okay, you can't bond out yet. Don't worry about the bond that we're posting out because you can't bond out just yet. All right? Yes.
Next file is that of Sandra Gonzalez. Is that you, ma'am?
Yes, ma'am.
All right, you have two allegations here. Possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. Do you want me to appoint a lawyer for you?
Yes, sir.
The Office of the Public Defender is appointed, Division 14. All right, next file is that of Hakeem Henry. All right. All right, Joe Huerta.
Yes, sir.
All right, sir, you've got a set of charges here. Trespass on property after warning, bond $100. Possession of methamphetamine, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defenders appointed, Division 14. All right, next file is that of Lano Jean.
Right? Here's the bonds for this.
Your name, sir?
Leno G.
All right, sir, you've got a charge here, burglary of a conveyance, bond $3,500. Do you want me to appoint a lawyer for you, sir?
Yes, sir, because I
All right.
have no one to
Office
bond.
of the Public Defender, Division 14 is appointed. All right, next file is that of Jose Maderos. Your name, sir?
Jose Madero, sir.
All right, sir. You've got a set of charges here. Driving while license suspended with 2 prior convictions, bond $2,500. And the other case is involving possession of drug paraphernalia, bond $500. You have completed the application for criminal indigent status. You do not qualify for appointment of the Office of the Public Defender Attorney at this time. You do have, let's see, Division 15 and CRA. All right, is that it? All right, the next case is that of Stephen Steen.
Yeah.
All right, sir, a charge here of violation of probation, and there's a conflict in the pleadings here, or the paperwork. You've got 0 bond on the face sheet, and where the judge signed the warrant has a bond of $5,000. So it appears that a $5,000 bond is indicated and has been ordered. Now, sir, there's no application for public defender, so that is Division 22. The public defender is not appointed because there is no request for one. All right, the next file is that of Daniel Vasquez. Your name, sir?
Daniel Vasquez.
All right, sir. You've got a new case involving possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. You are out on bond on identical charges. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender's appointed. Now, the bond on which you were released is hereby revoked. Next case is that of Jade Childs. Is that you, ma'am?
Yes.
All right, Ms. Childs, you've got a case here involving a charge of driving under the influence. And do you want me to appoint a lawyer for you?
Yes, please.
All right. Office of the Public Defender is appointed. That's Division A.
Your Honor, my client apparently qualifies for PTR in the revised sheets. She has no priors at all. Would such a action be possible at this time?
All right, so, all right, PTR be allowed. Cyril Ferguson. Sir, you've got a case here involving a charge of driving while license suspended or revoked. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed, Division A, and the bond, if I didn't previously announce it, is $500. Oh, he does? All right, I'm advised that we have yet another case, a probation violation out of Alachua County on which there is no bond. All right.
Apologies, so it was 500 on the traffic and no bond on the VOP, right?
Yes.
Thank you. All right, so we can't bond out just yet, we have that violation of probation. So call us when you wish you good luck.
All right, next case is that of Kevin Acosta.
Yes, sir.
Is that you, sir? All right. Sir, two cases, it looks like. A charge of petty theft on which your bond is $250, and then an Osceola County case for a violation of probation, so you have to answer that in Osceola County. Now, your bond on this new case is $250, and in this new case, do you want me to appoint a lawyer from the public defender?
Yes, sir.
All right, public defender is appointed, and that's CRA, it says. All right, Quantavia Jackson. Your name?
Quantavia Jackson.
All right, ma'am, you've got two charges here, trespass in a dwelling. The bond is $500 as to each one. Do you want me to appoint a lawyer for you?
Yes.
All right, public defender is appointed, says here, Division CRA.
Your Honor, if the defense may be heard on this matter, I'm concerned over a possible clerical error. My client allegedly trespassed in one dwelling before being apprehended. Yet I see two charges here for the exact same bond amount. I'm concerned that there was as I said, I'm concerned there was an error in the filing of the charges by officers on the scene. I don't think that's any. Let me see.
All right, input from the state.
One moment, Your Honor. Yes, sir, I believe that is an error. It should be one count of trespass in a dwelling. I do not, based on reading the arrest report, I do not see why two
All right,
counts were charged.
no probable cause as to count 2, then we'll say for the record, and public defender still appointed, and CRA.
Before proceeding further, Your Honor, I would like to ask, since we're down to one charge, if the state had an offer for my client, because we are on a misdemeanor pleadable.
No, Your Honor, the state does not have an offer.
If I may inquire as to records, I had additional notes for my client not qualifying for PTR. Is that still the case, or?
Yes.
Okay. Right, one moment. It is 500 at this time. Oh, no. Okay, that's our number cost when we can, that's the bond we're dealing with. Can you help with that? Maybe a bond can help, but I can't say for certain. All right, I want to wish you good luck.
Thank you.
All right, next file I have is that of Kelvin Mobley. Is that you, sir?
Yes, sir.
All right, sir, you've got a charge of loitering or prowling. Your bond on that case is $250 at this time. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender is appointed, Division CRA.
Apologies. If I may inquire as to the state, Mr. Mobley was only charged with loitering or prowling, and he doesn't. I have not been provided any history on Mr. Mobley. Does the state have an offer of a plea deal, or?
No, the state does not have an offer.
Very well then. Okay, so at the moment we don't.
Oh.
Are we talking about my client or the next man?
It's 2017 CF 009346.
And you have the name of the charge for the.
It's possession of cocaine and tampering with physical evidence.
All right. That being the situation on this loitering case, the bond would be increased to $750 from $250 on the new case.
Are you gonna take any action on the other case?
right, the next file is that of Daniel Penaloza. Is that you, sir?
Yes. My name is.
All right. Mr. Penaloza, you've got a charge of possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
All right. Public defender is appointed. That's CRA.
Your Honor, my client qualifies for PTR, and he's been assessed as a below-average risk. Would it be possible to put him on PTR at this time?
If he qualifies for PTR, the same would be allowed and granted. All right, next file is that of Antoine Tyson. Sir, you've got 2 counts here, 2 charges of trespass in a dwelling. Bonds are $500 each, and the total is $1,000, of course. And do you want a lawyer appointed, sir?
Yes.
Public defender appointed, CRA.
Your Honor, if I may, this seems to be the exact same issue we had prior. In fact, it even involved the exact same incident. As before, the police officer seemed to have put 2 charges on the same charge. Could we have I would therefore have a PC challenge to the second trespass dwelling issue.
All right. Count 2, no PC, and the total bond is $500.
Sir?
All right, Cameron Johnson. Is that you, sir?
Yes, sir.
All right, Mr. Johnson. Sir, you've got a set of charges out of Polk County, bond $1,000, and in addition, bond $500 for a total of $1,500. And let me check these here.
Is this cadet
Hmm.
Johnson and Barbara Ann?
Cameron.
All right, the attachment here provides that we have an active warrant for false imprisonment, bond $1,000, and a battery bond $500, and that's out of Polk County. So the total is the original amount, $1,500. All right, next file is that of Sean Safford.
Yes, sir. Yes, sir.
All right, sir, you've got, looks like a 2-count warrant out of Gadsden County. All right, for violation of probation. So you'll be transported there to answer those charges, sir. All right, next file is that of Carlene Cadet.
Yes.
Just a moment.
The state has an offer for this case, Your Honor.
All right.
The offer is adjudication of guilt 3 days and no return to the location.
All right, ma'am, the public defender's appointed. What says counsel?
A moment to confer with my client.
All right. What court costs on it?
And I didn't go on the property or in my apartment.
Wait, ma'am. State, in light, Mr. Barrington, in light of the fact that my client has no substantial priors, or any priors it appears, would a possible credit time served be, would be possible?
She has, history.
Huh. All right, hold on. Am I looking at the right sheet? Let's see here. I have,
It was updated.
oh, so this is my, this is
Yeah, she
income.
has 1 felony, 3 misdemeanors.
Okay, so she has history. That's very well.
County, and it's open.
The state is not willing to go lower than 3 days.
Okay.
All right.
That's the offer. Tomorrow.
He called me when I was walking with my boyfriend. We're
Wait.
both disabled. We're both disabled. He's out there on home. My mom is strong. I'll do it today. When we on the site plans. Mr. Jack. Does that make sense? To burn out, state?
Okay, wait, ma'am, please,
Do
ma'am, please,
anything.
ma'am, please, okay. All right. Your Honor, I apologize for the disruption. I would like to ask on behalf of my client if it would be possible to plead to the bench for a possible credit time served adjudication with no return to the scene and, of course, court costs. If not, then my client will have to choose between either the state's offer or fighting this further on.
It's my understanding, in my notes at least, I have adjudication, 1 day, credit for 1 day time served, no return, $273 in court costs payable in a year. Hmm? What?
The state offer was 3 days. You went up.
3 days? Okay, my mistake then. 3 days credit for 1. So, response?
Yes, Your Honor. In light of the fact that the trespass itself was relatively benign, and while my client seems to have priors, now that I've been informed, they are not recent. I do not believe she is a flight risk, certainly. Would it be possible to consider a credit time served if a plea to the bench were submitted?
Let me look here. All right, in regard to this, upon the entry of a guilty or no contest plea, the court would adjudicate guilty and, under the facts here, sentence to 2 days credit for 1, no return, and $273 court costs.
I still gotta pay the court costs. That was the original. No.
Okay.
That was the original bargain. Justification, no fee first. And still have to stay for it to come out.
All right. The next case then would be
Okay, do we
Barbara
like to
Johnson.
What's she gonna do? Wait, did she accept the deal or?
Judge moved on to the next case.
Okay. Okay.
All right, your name, please?
Barbara Johnson.
Ms. Johnson, you've got an open container with alcoholic beverages in it, and let's see, your bond is $250. You're entitled to appointment of a lawyer. You want a lawyer appointed.
He's asking if you want a public defender.
Yes.
Public defender appointed, Division A, offer from the state.
Adjudication, credit time served. And this is for Ms. Barbara Johnson.
273.
You get out of bed.
Well, they finally changed the clock. All right, so ma'am, you understand, by entering this plea, you're giving up your right to a trial.
Yes, sir.
All right, then the plea's accepted. There's a factual basis here. Adjudication of guilt. 2 days, credit for 2 days, time served. $273 court costs payable within 1 year. Say again?
Could we have Mr. Robinson reset for, Yes, but could we have him reset for tomorrow?
What?
Yes. Billy Robinson. Who you got?
I got Billy Robinson and Kiara Thomas.
Kiara Thomas. Bishop Bond. Judge, what's the, booking number for Kiara Thomas? 7618, 1900 7618.
Kiara Thomas?
Yeah,
She bonded.
she bonded.
Okay, good for her.
And Billy Robinson.
All right, Billy Robinson was brought in yesterday, looks like, but was mental health at that point.
He refused today.
Refused? Well,
You wanna reset one more time?
all right, well, try again one more time.
Thank you, Your Honor.
All right, if there's nothing further, then that would conclude this afternoon's docket. Are there any objections to that?
No.
Madam Clerk doesn't object.
These two documents, they missed what Carlin in there. We did that one, but you didn't take these.
Bond thing? Okay.
All right.
Okay. All right, bonded.